Myself, Tejas. My case for the presentation is Ammini J and others versus Union of India on 24th February 1995. Introduction. It is mainly based the case about the constitutional validity of Section 10 of the Indian Divorce Act 1869, for short, the Act which regulated divorce among Christians in India for a century and quarter is directly under challenge in two original petitions at the instance of two Christian women on the ground that the provision is Section 10 and violative of the fundamental rights guaranteed to them and other similarly situated Christian women under Article 14, 50 and 21 of the Constitution of India. Section 13 of Hindu Marriage Act. Section 13 clause 1 clause the subclause 1 of the Indian Hindu Marriage Act 1955 describes adultery as any marriage organized whether before or after commencement of this act may, on a petition presented by either the husband or the wife, be dissolved by decree of divorce on the ground that the other party has, after the solemnized of the marriage, had voluntary sexual intercourse with any person other than his or her spouse. Essential elements of this act there should be an act of sexual intercourse outside the marriage and that such intercourse should be voluntary. Section 497 of the IPC. Section 497 of the IPC defines adultery whoever has sexual intercourse with a person who is and whom he knows or has reason to believe to be the wife of another man without the consent of convenience that man in such intercourse not amounting to the offence of rape is guilty of the offence of adultery. The adultery is extramarital sex. It is consensual sex intercourse between a married person and a person of the opposite sex, not being the other spouse, during the subsistence of the former's marriage. If the other party has, after the solemnization of the marriage, had voluntary sexual intercourse with any other person other than his or her spouse, a divorce or a judicial separation petition can be filed. Section 10 of the Hindu Marriage Act 1955. Under the Section 10 of Hindu Marriage Act 1955, even a single or isolated act of adultery will entitle other party to seek judicial separation from his partner before the enactment of the marriage laws amendments. 1976 adultery was treated as the conduct of grave immortality. It was a thing of grave shame irrespective of the gender. However, it was a ground for divorce. But before passing of Marriage Laws Amendment Act 1976, in order to obtain a divorce on this ground, the petitioner had to prove that the other party was living in adultery, which would cover more or less continuous and habitual course of action. An isolated act or immortality was not sufficient, but after the passing of the Act 1976, even a single and isolated act of indefinitely would be infidelity would be a sufficient ground to obtain a divorce. The spouse who wants to file a divorce petition has to substantiate the statements with proper evidence. The burden of proof in the case of adultery always lies on the petitioner. The offence of adultery must be proved beyond the reasonable doubt. Next we are moving to the needs of the proofs which are needed to file an adultery. Okay, the proofs are needed are as follows: circumstantial evidence, evidence of known access and birth of children, contracting of venereal diseases, evidence of visit to houses of ill repute, decree and admissions of parties which should generally be corroborated. The sexual intercourse was willingly indulged into by the respondents. The actual penetration need not be proved. It can be proved by a preponderance of probabilities. And the summary of the case, in this case, the Kerala High Court held that the husband is in favorable position with respect to it being a ground of for divorce, because the wife has to prove adultery along with some other aggregate ag- aggravating circumstances, and hence it is discriminatory towards the wife. The court also ruled that wife may file a divorce only on the ground adultery without any other qualifications, such offences as such as cruelty or desertion. And the conclusion is man and woman observe utmost secrecy about their meetings even when it's lawful. When it is unlawful, they take extra care. This makes direct evidence of adultery extremely difficult. Therefore, if the law insists on direct evidence, few cases will be proved amongst hundreds and thousands. The result will be that the security of the marital marital rights against adultery will be reduced to a nullity. Adultery is Adultery is proved circumstantial evidence. If circumstantial evidence of adultery is to be admitted, the proof of penetration has to be dispensed with. If the adulterers are proved to be in such juxtaposition or associating in such circumstances that the sexual act may be inferred, the court will also usually be satisfied that the adultery has occurred. Thank you.